Hi, and welcome everyone to the second event in this year's Talking Animals Law and Philosophy series. My name is Raphael Fazell, and I am the Executive Director of the Cambridge Centre for Animal Rights Law. For those of you who are attending the Talking Animals Law and Philosophy series for the first time, here's a quick note on the format of this event. We're going to have a presentation by our speaker that will last for around 45 to 50 minutes, and we'll then have a good hour or more for Q&A and discussion. Now, I would be grateful if you could use the raise hand function in Zoom. If you'd like to make a point or ask a question during the discussion, you will find that function under the participants button. This will allow me to just go through the different hands that may be raised during the Q&A part, and you can ask your questions directly to the speaker, which I think is very nice usually and allows the speaker to respond to you in person, as it were. Now, until this point, until we reach the discussion part of the event, I will be muting all the microphones. If you find yourself unable to locate the raise hand function, you can also just use the chat function if that's easier for you. Okay, let me now turn to our speaker of today. It is a pleasure for me to introduce to you Jodi Lazare, who is Assistant Professor at the School of Law at Dalhousie University in Halifax, Canada. This is where she teaches and researches in constitutional law, animal law, and family law. Prior to her appointment, Jodi completed graduate studies in law at McGill University in Montreal, as well as a one-year clerkship for the Justice Michael Moldaver of the Supreme Court of Canada. Jodi currently holds an Insight Development Grant from the Social Sciences and Humanities Council of Canada to study the constitutional dimensions of animal rights activism and the restrictions on that activism in the form of newly adopted agricultural gag laws. Now, it is about these laws that Jodi will be telling us more in her presentation, Ag-Gag in Canada and the constitutional right to see. Jodi, thanks a lot for joining us. The floor is yours.
Okay, thank you, Raphael, for the introduction and for the invitation. It's a pleasure to be here, and it's exciting that people are here and interested in the subject. So thank you to those who have tuned in as well. So I will just share my screen, and you can see that?
Yes.
Okay, perfect. So my talk, as we've heard, is called Ag-Gag in Canada and the Constitutional Right to See. Not surprisingly, it's about Ag-Gag legislation or agricultural gag laws and their recent arrival in Canada and their constitutional implications in the Canadian context. So for those who don't know, Ag-Gag laws are, they became popular about a decade ago in the United States. And while there are kind of many forms of Ag-Gag laws, what they all have in common is that they limit free speech as a means of insulating corporate agriculture from scrutiny and from public criticism. So I'll elaborate shortly on what they look like in Canada. But first, I'm just going to take you through what I will touch on today. So in short, I'm going to take you through an argument that these laws are unconstitutional in Canada, in my opinion. That is that these laws recently adopted in 2 Canadian jurisdictions and on the horizon in a couple of other Canadian jurisdictions, I will argue that they constitute an unjustifiable limit to the charter protected right to freedom of expression. And I will break that down as I go. It's a bit of a mouthful. So first, I will provide some background. I'll highlight a couple of recent incidents where animal rights activists have either trespassed onto farms to expose animal suffering, conducted undercover investigations revealing really indescribable cruelty, or participated in save movement vigils outside of slaughterhouses so as to bear witness to animals in the final moments of their lives. After that, I'll take you through the legislative landscape and recent developments in Canada. Following that, I will talk a little bit about the legal context surrounding animal rights activism and the introduction of Ag-Gag legislation. That is, I'll talk briefly about what the law does for farmed animals in Canada. And I'll give you a preview on that one, which is that there's really not very much to say about the legal regulation of the treatment of farmed animals in Canada. It's pretty grim. The next two parts are really the crux of my argument. So first, I'll explain my reason, my reasoning that animal rights activism constitutes protected speech in Canada. So in other words, that part, animal rights activism as protected speech, argues that Ag-Gag legislation constitutes a limit or a breach or a violation or what have you of fundamental freedoms protected by the Constitution. And I'll just add here, to avoid any confusion, that I use the terms Constitution and Charter interchangeably. The Canadian Charter of Rights and Freedoms, essentially a constitutionally entrenched Bill of Rights, is part 1 of the Constitution Act 1982. So the Charter is part of the Canadian Constitution, a significant part. And then second, I'll take you through my thinking to suggest that the limit to freedom of expression is not justified. And I'll explain that a little later as well. But in short, the Charter has a limitations provision. It tells us that rights can be limited if the government demonstrates that doing so is justified. But in my view, as I'll explain, this limit in the form of Ag-Gag laws cannot be justified on the available evidence. And I'll explain that more fully as well. And then finally, I'll sum things up briefly with a sort of bigger picture summary of the problem. And then, of course, I'm open to questions, suggestions, clarifications, or what have you. I'll just say, just so you know where I'm coming from in terms of the background here, this talk is based on 2 papers. So I divided the constitutional analysis into its 2 parts, the rights violation and justification. And the first one on the rights violation is published. It came out recently in the Alberta Law Review, which is an open source journal. So I'm happy to share that link if people are interested. And the second one on justification is still underway. I'm hoping to submit it to a journal, in the next few months. So I'm very open to feedback or ideas, or even just questions that might help me clarify my thinking there on the justification piece. All right, so here we go. In September 2019, about 90 animal rights activists staged a sit-in at a southern Alberta turkey farm to protest what they viewed as inhumane treatment of the resident birds. Some of the protesters, who are members of a group called Liberation Lockdown, they locked themselves inside of the barn, and they demanded that the media be allowed to film inside the turkey pens, and that some turkeys be liberated from confinement. And while the owner of the farm disputed any claims of animal mistreatment, stating that the farm follows the standards set out by the Alberta Turkey Producers Association, the ultimate objectives of the activists was to expose the really harsh reality of what happens on Canadian farms. In December of the same year, also 2019, 11 animal rights activists, members of Direct Action Everywhere, occupied a pig farm south of Montreal in an attempt to push the Quebec and Canadian governments to end industrial pork production. So the activists there streamed their footage of the occupation on Facebook, denouncing the conditions in which the animals were kept and showing that the animals did not have enough space to turn around, which is typical in Canadian agriculture for pigs. So in response, the president of Quebec's Pork Breeders Association said that Canadian animal welfare standards are among the highest in the world, which is an interesting statement, as I'll explain a little later. In February of this year, animal rights activists occupied a duck farm and blocked a main roadway in Newmarket, Ontario, which is about an hour away from Toronto. The company's website describes it as a leader in animal care, claiming that ducks are raised free-run in large, spacious barns with plenty of fresh air and ventilation, unlimited water, and natural feed, and that the barns are bedded down with recycled fresh wood shavings daily and washed out for maximum sanitary conditions. The activists, however, who also stream their activities on Facebook, they found ducks that were injured, sick, and dying or already dead in the dark, free-run barn. Others had legs, wings, or beaks stuck in the wire flooring that they were standing on. So in this case, Animal Justice, which is a national legal advocacy group for animals, they filed a false advertising complaint with the Competition Bureau of Canada and the Canadian Food Inspection Agency. You know, it's not the first kind of it's not the first complaint of this kind, and these claims really typically don't go anywhere, but they're useful nonetheless. I'm just going to give two more examples of the kinds of things that spurred the introduction of Ag-Gag in Canada, and these last two are a different form of advocacy or activism, both of which are also targeted by the legislation. So in June 2015, a number of animal rights activists gathered on a Toronto traffic island beside a truck carrying almost 200 pigs to an adjacent slaughterhouse. And this is, of course, a regular occurrence at that particular intersection. And it has been, and in many other places as well, and it has been since 2011. So the SAVE movement, members of which hold regular vigils like this outside of slaughterhouses, has since 2011 expanded to more than 165 groups around the world. Their main activity is to bear witness to the suffering of industrially farmed animals, and they attempt to bring them some comfort in the form of gentle words or gestures like this one, or water on hot days. And I included a visual for this particular, story because I really think that that's become kind of an iconic image where the SAVE movement is concerned. So Manisha Dekka at the University of Victoria, she's written about the SAVE movement. She describes their practices as making visible the spaces where killing takes place and the structural means by which consumer cultures aid and abet that killing, and sharing audio and visual recordings from the visuals via social media to broader audiences. So on that particular day in June 2015, Anita Krines, the founder of the SAVE movement, got into a verbal confrontation with a truck driver when she attempted to give some water to thirsty pigs. I won't go into the details of the exchange. It's of course available online. Everything is filmed. Ms. Krines was then charged with the criminal offense of mischief. And after a week-long trial in 2016, she was acquitted of the charge, sort of confirming the group's mantra, compassion is not a crime. And then finally, this is the last vignette I'll go through, so to speak, and I don't have visuals for this one because honestly, they're horrific. In 2014, CTV, which is a national Canadian broadcaster, aired what has been described as shocking video or horrific animal abuse at the largest dairy barn in Canada, in Chilliwack, British Columbia. And I'll give a brief warning here, I guess. I will describe some of the stuff on the video, so if you're sensitive, you should turn your sound off for a couple of seconds. So the video showed cows being whipped and beaten with chains and canes, being punched and kicked, as well as cows suffering from open wounds and injuries and being lifted by their necks with chains and tractors. So that footage was shot by a former employee of the farm on behalf of the animal rights group Mercy for Animals. And in addition to charges for some of the perpetrators of the abuse, as well as the owners of the farm, the investigation and the resulting media coverage led to boycotts and hastened industry reform for dairy production in Canada. All right, so why take you through all of this? That was a bit lengthy. 3 reasons. First, I think these kinds of activities are increasing in frequency in Canada. Undercover investigations and sort of covert rescue by animal rights activists has been happening for years, for a century at least, in the United States. In Canada, while I don't have exact numbers, it seems like the rise in social media and the ease with which people can now share video with thousands or even millions of people, essentially for free, I think that that's contributed to the rise in this kind of activism. Second, these kinds of activities play a crucial role in advancing legal protections for animals. Research from the United States suggests that the work of these investigative groups is emerging as the primary information source about animal welfare for consumers. And that's in large part because public relations campaigns by the industry only tell one side of the story, right? Industrial farms, slaughterhouses especially, they're not open to public view, which means that where public access to knowledge about food production is concerned, and here I'm going to quote from Chen and Marceau in the US, there is no viable alternative to an undercover investigation of the commercial agricultural industry. So in short, animal rights activism in the form of farm occupations, protests, undercover investigations, and the resulting exposés, it produces information that is otherwise kept hidden, but that's fundamental to revealing and then to dealing with some of the horrible abuses that take place on industrial farms. And it's crucial to public discourse on society's treatment of animals and on the ethics and morality of meat consumption and food production methods. The third reason these stories are relevant is pretty simple. They've given rise to industry and legislative reaction in Canada, following in the footsteps of the US in the form of Ag-Gag legislation, which I will turn to now. So, starting with Alberta. So for those who don't know, Alberta is a sort of landlocked prairie province located on the western side of the country. It's often referred to as out west. It is well known for its socially conservative politics, its seemingly unwavering support of the oil and gas industry, the well-known annual Calgary Stampede, and of course, beef farming, among other animal farming. But Alberta beef is it's a well-known thing. In December 2019, Alberta amended a number of trespass-related statutes, all contained in one bill, Bill 27. So for our purposes, the most relevant effect of Bill 27 is to prohibit unauthorized entry onto private property so that every person who enters without permission of the owner or occupier of the land or fails to leave immediately is guilty of an offense. So for an individual, regardless of whether they damage the premises, the penalty for a first offense is a fine of up to $10,000, up to $25,000 for a second offense, and imprisonment for up to 6 months or both. And then for organizations or corporations or organizations, they are subject to fines of up to $200,000 for every instance of trespass or for counseling or aiding in the commission of an offense, even where the offense does not take place. So this is perhaps a little draconian, maybe, but arguably legitimate, right? Provinces can regulate with respect to property. What they cannot do, what no government in Canada can, is unjustifiably restrict or punish the utterance of specific words or spoken messages, which Bill 27 also does. It states that for the purpose of the trespass provision, a person who obtains by false pretenses permission to enter on land is deemed to have entered without permission, i.e. to have trespassed, and is therefore subject to those severe penalties. So Bill 27 was adopted very quickly, 17 days between first reading and royal assent, but there is a little bit of legislative debate and Hansard, and that contains some explanations of the legislative objectives here, including the intention to, I'm quoting from the Hansard, make sure that property rights are respected in the province of Alberta and that landowners can feel safe in their homes, knowing that law-abiding citizens are protected. Also, the introduction of the bill was preceded by a discussion of so-called animal rights activist farm and ranch protests and the need to protect business owners like turkey farmers. Recall the first story I told you about the turkey farm occupation took place in Alberta. And there is also discussion of the occupation of a sled dog facility. So that is Bill 27. In Alberta, there is a second law, Bill 1, which is now a law in force, called the Critical Infrastructure Defense Act. And like Bill 27, it also targets activism. So I'm quoting from the Hansard here again. It increases the dissuasive effect of law against those who would seek to hold us all jeopardy to their radical demands. They, of course, being protesters and activists. Now, this is not limited to agricultural operations. Neither of the bills in Alberta are. But whereas Bill 27 is limited to trespass onto private property, Bill 1 prohibits the willful obstruction, interruption, or interference with any essential infrastructure, the definition of which includes highways and agricultural operations. So Bill 1 was not adopted, at least not exclusively, in response to animal rights activism. Rather, it was introduced primarily in response to blockades, and clearly I'm quoting here, by green zealots and eco-radical thugs opposed to pipeline development and oil and gas extraction, which is of course a major issue in Western Canada. But the breadth of the bill means that it could easily capture farm occupations and the types of activities carried out by the SAVE movement, as it prohibits interference with highways and agricultural operations. Before I move to Ontario, I'll just mention that Bill 1, or the law, the Critical Infrastructure Defence Act, is currently the subject of at least one constitutional challenge with respect to freedom of peaceful assembly, i.e. the right to protest, which is a constitutionally protected right in Canada. So in June, the Provincial Employees Union launched a constitutional challenge to the law, given its restrictions on protests and therefore picketing activities. But in terms of challenges to any of these laws or AgGag law in general, that's the only one sort of in progress now. So no animal law folks have challenged these yet, but quite sure that's only a matter of time. So turning to Ontario, and I'll keep this brief. It's not that dissimilar to Alberta, but it's relevant because Ontario is the most populous province in the country, and it has a very significant agricultural sector. So in June 2020, Ontario adopted the Security from Trespass and Protecting Food Safety Act. The slide is just the long form of the title. It's not entirely in force yet, as I'll explain, but basically it does very similar things as the two Alberta statutes, but here limited to agricultural operations. It also doesn't include the possibility of jail time or the increased penalty for corporations or organizations. So it's not quite as severe. But it does do the same thing regarding entry on false pretenses. And the Ontario law is also very clear that it is targeting the SAVE movement. The incident that led to the trial to Anita Crines's mischief charges took place in Ontario. So the law says that no person shall stop, hinder, obstruct, or otherwise interfere with a motor vehicle transporting farm animals, and that no person shall interfere or interact with a farm animal being transported by a motor vehicle without the prior consent of the driver. It's clear who this law is targeting. I think it's worth mentioning that since the adoption of this law and the transport part is in force right now, demonstrations outside of slaughterhouses in Ontario seem to have increased in frequency. And possibly as a result of the law, tensions between animal rights activists and supporters of animal agriculture have also increased. So in June, I think the day after the bill received royal assent, Regan Russell, a longtime animal rights activist and member of the SAVE movement, was struck by a transport truck and killed while bearing witness outside a Toronto slaughterhouse. Some people have drawn connections between her death and the adoption of this law. And since then, supporters of animal agriculture have held counter protests alongside the SAVE movement vigils, confronting activists, alleging that Russell committed suicide, and barbecuing hot dogs next to the trucks transporting pigs to slaughter. So this is a live issue currently, and tensions around this are really high. So before I move on, I just want to be clear about what exactly these laws do and why they're a problem. I mean, the transport stuff is pretty obvious, but on their face, the laws don't appear to target undercover activities, like an activist obtaining a job on a farm on behalf of, say, Mercy for Animals, in order to film and expose cruel practices. You know, it looks like, insofar as the trespass provisions are concerned, that the laws are actually aimed at trespassers, right? People who enter a property without permission to do so, like the first couple of stories there. However, the false pretenses provision actually have a much more serious effect, because in concrete terms, say an individual is an investigator for an organization like Mercy for Animals or Direct Action Everywhere or what have you, if that person, say that person applies for a job on a farm with the intention of filming and publicizing cruelty, but does not disclose their affiliation with the organization when they're hired, pursuant to the false pretenses provision, that individual would probably be entering on false pretenses and subject to those massive penalties. I say probably because that part of the legislation is not in force yet. And following the legislative committee hearings in June, where I and others expressed our concerns about the constitutionality of these provisions, the bill was amended so that the false pretenses have to be made in the prescribed circumstances and prescribed reasons in order to constitute trespassing, and that's a reference to a regulation which has not yet been introduced. But it's hard to imagine what circumstances and reasons the legislator might have in mind here other than investigations out to reveal cruel practices on farms. Okay, so those are the statutes in question. I mentioned other Canadian jurisdictions, but I won't really get into that other than to say that at least 2 other provinces, it looks like there is AgGag in the works in Manitoba and Quebec. There is also a federal bill in progress, which I will say a bit more about later on. And if people have questions about the difference there or how that works sort of jurisdictionally, happy to answer those as well. Next on the menu. And I'll be brief here because I want to really get into the legal analysis of the laws themselves, but this is just a quick explanation of the reason that animal rights activism, occupations, and exposés are really quite important in Canada, and this time grounded in the law. So the short of all of this is that there are no laws in Canada regulating the treatment of farmed animals while they're on the farm. Of course, the criminal code, which applies across the country, contains an animal cruelty provision, a prohibition dealing with willfully causing unnecessary suffering. Anyone who knows anything about criminal law right there can see that that's going to be a difficult hurdle because of the wording, willfully causing unnecessary suffering. It's a really high mens rea requirement. And it's been interpreted to contain an exemption for generally accepted agricultural practices. So provided something is done with regularity on farms, no matter if it's painful or causes suffering, it won't be interpreted as unnecessary suffering because it's necessary to kill animals for food, essentially is the reasoning. Then there are provincial statutes, and they all contain prohibitions on causing distress. And unlike the criminal code, but here expressly, they all contain an exemption for generally accepted agricultural practices. Some of the provincial codes also contain a reference to the NFAC, or National Farm Animal Care Council codes of practice. And I don't want to get into great detail on these. There's a really good article by a colleague of mine at the University of Alberta, Peter Sankoff, describing those codes. They function in a similar way to animal welfare codes of practice in New Zealand and Australia. But basically, those are non-binding codes of practice. And the bottom line here is that they're created majoritarily by industry stakeholders. There may be an animal welfare representative on the committees, but they would be a very small minority in a group of industry stakeholders like farmers themselves, farmers associations like the Canadian Cattlemen's Associations, and restaurant and industry groups as well, like McDonald's or what have you. They're also of ambiguous legal status in that they don't, not adhering to a code doesn't constitute an offense, but adhering to a code is a defense. Anyway, that's a bit complicated, so I'll leave that there. The point there is, and I'll quote my friend Camille Labchuk, who's the executive director of Animal Justice, who says that the INFAC codes of practice are like the fox guarding the hen house. A bit problematic, but better than nothing. There is also a Health of Animals Act and regulations. Those deal with transport of farmed animals across provincial lines. And what I'll say there in brief is that Canada has the worst animal transport regulations in the developed world. It's particularly interesting talking to an audience over there where you are, because compared to England and Europe, or the UK, it's shocking, up to 72 hours without food, rest, or water for some animals, 36 hours for cows, 28 hours for pigs, in open-sided vehicles with no clear instructions with regard to temperature, ventilation, that kind of thing. You'll know that Canada has extreme temperatures. It's -40 here in the winter. So imagine being in an open-sided metal truck in -40, moving at 100 kilometers an hour, and it's +40 in the summer. So they're really not good. And millions of animals arrive dead at slaughterhouses. That's just the reality of animal farming in Canada. There's also the Safe Food for Canadians Act, which contains one provision about avoiding undue suffering at slaughter. I don't think it's ever been judicially interpreted. It's a new law. So this should explain why the push for reforms is important and why showing what happens on farms might help and in transport might help push for those reforms. All right. So here we are, constitutional arguments, beginning with how and why restrictions on animal rights activism constitute a limit to Section 2B of the Charter, which is the guarantee of freedom of expression. Now, to be honest, I think this is a fairly straightforward argument. The bar for proving a limit to a fundamental freedom in Canada is actually quite low. The truth is that the real work here comes at the level of Section 1 justification, but as I'm aware that most of this audience is not Canadian, I'll spend a bit of time on this. So starting with the trespass provisions and the prohibition on entry under false pretenses. And just for the sake of clarity, I'm going to focus mostly on Ontario here. It's just easier to reference one statute. But I do think that everything I say about the Ontario law with respect to its constitutionality would apply in the same way to the situation in Alberta, or even more forcefully in Alberta because of the possibility of imprisonment. So in short, where the trespass provision is concerned, it really is simple. The statute, by making entry under false pretenses a punishable offense, is restricting a type of speech. You know, that speech may be an omission or even a lie, but it is speech nonetheless. And the bar for protected speech in Canada is very, very low. Hardcore pornography is protected speech. Erotic dance shows are protected speech. Certainly an untruthful statement in order to gain entry onto a farm is protected speech. Also, as Marceau and Chen have written in the American context, the effects of the prohibition actually are much more serious than just prohibiting someone from telling lies, right? The speech here is speech precedent, to borrow from the American literature, to political speech, right? To speech meant to influence our consumer choices about what we buy, about what we eat, and about what we support with our dollars. Now, whether or not the speech has those effects, I think is probably something that needs more research, which I'd love to do. Although I think there is at least anecdotal evidence in Canada that it does, and there is better, peer-reviewed evidence in the United States in terms of the effects of undercover investigations on dietary and consumer choices. So another way of thinking about this is that the expression here has informational value, which the Supreme Court of Canada has said merits constitutional protection. And even more on point, the Federal Court of Canada recently extended that reasoning to apply specifically to choices around ethical food consumption. So last year, the court determined that food product labeling requirements, which relate to the ethical dimension of a product's creation or origins, this was about wine being produced in the occupied territories being called a product of Israel. So engaged some political questions for sure. The court there determined that those labeling requirements engage charter values of both freedom of expression and freedom of conscience, and that the failure to disclose that kind of information relating to a product's origins or production, things that might influence a person's purchasing choice does constitute a limit to freedom of expression. So this, the stuff being stifled by Ag-Gag is expression with informational value. It is also political speech, which the Supreme Court has called high value speech. So that speech that lies at the very core of freedom of expression and the reasons that our Constitution protects freedom of expression, which means it should be difficult to justify limits on that kind of speech. So on that, the political speech question, bearing witness, the activity targeted by the transport provision, is clearly political expression. So again, Manisha Dekka has described bearing witness as an exercise in truth-telling with the potential to stimulate criticism and change where the food system is concerned. She says it's a form of social signaling and a means of expressing publicly visible compassion to humans who have never questioned the animal agricultural system, but who are eyewitness to, for example, Toronto Pig Saves protests in person or online. It's worth pointing out again, I think, that the members of the Save movement and others who hold vigils outside of slaughterhouses, that they record their activities and they make them available to the general public. So Marceau and Chen have written that the dissemination of these kinds of videos informs moral and political debates and is critical to advancing public discourse and influencing policy reforms. Others might know of Timothy Pacharat's work on the politics of sight, which he describes as organized, concerted attempts to make visible what is hidden in order to bring about social and political transformation. Catherine Gillespie is an American ethnographer, and she makes this very clear when she writes that the act of witnessing animals' predicaments and then sharing their stories is a political act that resists the erasure of individual animal lives, suffering, and death. And scholars like Josephine Donovan and Carol Adams, writing within the feminist ethic of care tradition, which of course has a lot to say about our relationships with animals, they argue that attention to suffering necessarily involves attention to the political and economic systems that are causing the suffering. So the messages of animal rights activists, in other words, are a form of political expression, which lies at the heart of the constitutional guarantee. So all of this makes me fairly confident in suggesting that it would be a mistake on the part of a court to ignore the political dimensions of the activities or the activism targeted by AgGag legislation. Okay, so assuming we're in the presence of a clear limit or a restriction on freedom of expression, before I press on with the analysis, I'll just do a brief parentheses or Canadian Charter Litigation 101. So as I mentioned earlier, there are two parts to a constitutional analysis, or more specifically to a charter challenge. First, a claimant has to demonstrate that a fundamental freedom is in fact being restricted by a law. And I hope I've made the case that Ag-Gag does restrict freedom of expression. And the second part is the justification analysis. So here, the burden shifts to the government to demonstrate that the limit is justified in a free and democratic society. And that's the wording of Section 1 itself. So I just want to highlight those two parts that I put in bold and underlined there, that the limit needs to be reasonable and, and more importantly, I think that their reasonableness needs to be demonstrably justified, as in demonstrated based on the best available evidence. So when I teach constitutional law to second-year law students, I really try to drive this point home with my students that the Section 1 analysis is not an abstract idea or framework. Rather, it is a concrete test based on tangible evidence, which means that where there is no evidence to suggest that a limit is reasonable, it cannot be justified under Section 1. And in my respectful opinion, given the absence of evidence, which I will get to right now, and the importance of the speech in question, I don't think this legislation is justifiable. So again, the analysis itself. It is up to the government to prove first that the legislation is aimed at a pressing and substantial objective. What this means, legislation has to be aimed at what the courts consider a valid or sufficiently important legislative objective, sufficiently important to override constitutional freedoms. And basically, this stage of the test is meant to ensure that legislation aligns with state values like human rights in the general social arrangement, to borrow from Aaron Barak, an acknowledged expert in proportional rights balancing. Now, what that means, of course, is open to interpretation, but whatever it is, I don't think that this legislation aligns with state values and respect for human rights. And that's because I haven't seen or heard of any evidence that trespassers actually threaten biosecurity or farmer safety, which is, of course, the stated objective. The people I have heard from, the people doing the activism, they're very clear that they take all measures necessary in order to protect the animals and that they have no interest in violence against humans. So in fact, testifying before the legislative committee, studying the Ontario law, one animal rights activist who has repeatedly trespassed onto farms, she told the committee that activists will just avoid contact with people. If there are people around, they just won't go there. And of course, they take extreme biosecurity measures. They wear masks, and they did prior to COVID. And they're often seen in hooded, like protective gear or biohazard suits to avoid introducing any contaminants to animals. So that really undermines the first three objectives listed on this slide. Before I get to the economic objectives, I'll just deal with that last one there quickly. The objective of prohibiting public protests, because that's a reference to the Alberta Hansard, which was express about the objective behind Bill 1. And this will be quick because, quite frankly, I would be very surprised if a court accepted that the prohibition or prevention of public protests is a valid legislative objective. Legislative objectives or purposes cannot, a pressing and substantial objective under the Charter cannot run counter to other fundamental freedoms in the Charter. And the right to protest, as I mentioned, is expressly protected in the Charter. It's Section 2C. So that's just not a valid legislative objective. The economic question is an interesting one, in my opinion. As a general matter, the Canadian Charter has not been interpreted to protect economic rights, and that's a source of controversy. So there is no right to earn a living or right to property, for example, not yet anyway. There's also not a lot of case law dealing with economic protection or industry protection as a valid, pressing, and substantial reason to limit charter rights. So what's interesting here, though, is that the few cases that do discuss it happen to deal with agriculture and farming, specifically statutory exemptions from organized labor regimes for farm workers. In other words, decisions dealing with challenges to the constitutionality of laws saying that farm workers cannot unionize, which is contrary to the Charter guarantee of freedom of association. So in a 2001 decision, a majority of the Supreme Court of Canada reasoned that the protection of the family farm is a pressing enough objective to warrant the infringement of Section 2D of the Charter. Now, of course, the key there is the reference to family farms, because in the same decision, the court acknowledged the erosion of family farms as typical of Ontario agriculture. And the majority's reasoning on Section 1 here was limited to these smaller farms and their unique, I'm quoting from the decision, unique and non-commercial way of life, and not to corporate farming and agribusiness. So again, I don't have exact data on this, but I would suggest that the erosion of family farms is even more apparent today, 20 years later. Heather McLeod-Kilmurray is a Canadian legal scholar who has written on the environmental impacts of industrial farming. And she describes the vertical integration of industrial farms in Canada, or ILOs, intensive livestock operations, which are akin to CAFOs in the States, concentrated animal feedlot operations. So my point here is that the so-called family farms that were the focus of the court's attention in 2001, those are slowly disappearing in Canada as they have in the US. And the protection of the economic interests of corporate agribusiness has not been accepted as a pressing and substantial reason to limit constitutional freedoms. I'll just add as well that in that same decision, one dissenting judge actually declined the invitation to find that a policy geared to enhance the economic well-being of private enterprises was sufficiently important to meet the first step of justification. So all of this to say that the really significant economic interests, which seemingly form the motivation for Ag-Gag, and there is a lot of talk about that in the Hansard, combined with the erosion of family farms and increase of industrial agribusiness and the uncertainty around the pressing and substantial nature of economic interests as a general matter, all of that might lead a court to find that the protection of industry is not, in fact, a valid reason to limit charter rights. But that was a bit complicated. I'm happy to come back to that in questions. But anyway, it's an open question still, and it's something that I would like to explore further, and I'd be quite curious how a court would deal with this. Because the fact is, courts have set a very low bar for proving a pressing and substantial objective. So while it does happen, it's very rare that a law will fail at this stage. So I will keep going. We're almost there. So for our purposes, the next two parts of the justification test are actually the most relevant. Justification requires that the legislative measure or the offending law in question is rationally connected to the legislative objective. So again, the law and the materials accompanying its introduction back in December are very clear that the objective here is to protect farmer safety, animal safety, and biosecurity, to prevent the risks associated with people trespassing onto farms. Now, as I understand things, trespassers are not gaining entry based on false pretenses, right? They're not posing as employees. They're not undercover investigators. They're protesters. They don't get permission based on truth or on a misrepresentation before they enter farms, right? They just enter or trespass as per the definition of trespass. So the false pretenses provision, as I mentioned earlier, looks like it's aimed at something else, right? Something more covert, like those who might pose as employees in order to act as whistleblowers. The problem here is that there is nothing to suggest that those people, undercover investigators, threaten biosecurity. They are employees who are trained in the same way and follow the same rules as everyone else, right? So they're not the cause of the mischief being targeted, in other words, which means that limiting their speech is not rationally connected to the legislative purpose. And that's enough for a constitutional challenge to succeed. That's also a big part of the reasoning underlying a number of American cases dealing with similar legislation restricting entry based on a misrepresentation. And we can say similar things about interfering with animals on a truck, right? In the pig trial, the crimes trial, the Crown tried to suggest that the accused might have been poisoning the pigs with some unknown chemical and consequently contaminating the food system. The judge rejected this argument based on the evidence that the pigs in question were subsequently offloaded into the slaughterhouse and processed as usual. So that might undermine the suggestion that the activity of bearing witness, of offering comfort and water to thirsty pigs, and of sharing that experience with the public, that any of these things constitute a threat to biosecurity. There is also the question of safety. I mentioned the tragic death of Regan Russell in June, but what's important to keep in mind here is that the legislative debates do not contain any meaningful suggestion that the legislator was concerned about the safety of activists. You know, the law is about protecting animals as commodities, as well as the safety of truck drivers and farmers. And I'm personally not convinced that an individual interrupting an 18-wheeler or interacting with its cargo, so to speak, really poses a threat to the safety of the person sitting in the cab. One more thing on rational connection. I would go even further here, and I would suggest that not only is there no rational connection between the limits to free expression and the legislative objective, in fact, the law actually undercuts its own objectives. Studies from the US suggest that Ag-Gag legislation actually hurts the industry. It makes people question what it is that industrial farmers are trying to hide. It erodes public trust, and it actually increases popular support for animal welfare reforms. A law that completely undermines its stated objectives is not a law with a rational connection at the level of Section 1. And this absence of a rational connection, again, is enough for the law to fail. But there's more. And this is the last thing that I'm going to take you through. Because this next step, the requirement that a law be minimally impairing, in other words, that it limit rights no more than necessary to achieve its objective, this is where legislation typically fails a charter challenge. I tell my students that minimal impairment is where laws go to die. So this part of the test means that legislators must use the least drastic means in terms of rights violations to achieve their objective. And the bottom line here is that there are ways to achieve the objectives here, protecting biosecurity and farmer safety, that have less of a drastic impact on fundamental freedoms and specifically on freedom of expression. Simply raising the penalties for trespass, for example, like both laws do. Not ideal for trespassers, certainly, but would not create the same kind of restriction on high-value speech or expressly prohibiting the introduction of biosecurity threats. So there is, in fact, a private member's bill currently making its way through Parliament that would do precisely this. It would prohibit entry to a place where animals are kept when that entry could expose animals to a disease or toxic substance, basically a prohibition on introducing a biosecurity threat, which looks to me like a fairly effective way of protecting biosecurity, again, without trampling on constitutional rights. So I'm going to leave it at that. In terms of the charter analysis, there is technically a third part to the justification test. It's kind of a cost benefit analysis, but it's a bit of a wishy-washy test, and no law has ever failed at that stage of the analysis. So instead, I'm just going to close by saying, technical and formalistic arguments aside, these laws are honestly, unfair and undemocratic. The idea that an entire industry should be immunized from public scrutiny is shocking, especially as we learn more every day, not only about the violence and suffering perpetrated by industrial agriculture on animals and on humans, but also about the irreversible impacts on our shared environment and on public health and safety. And this, in the midst of a global pandemic of massive proportions caused by a zoonotic disease. So what I argue that what we need is more oversight, not this complete absence of transparency, and that we need laws that respect the fundamental rights of individuals to make public the ways that we relate to non-human animals and to the natural world around us. And AgGag laws, just as they did in the US starting a decade ago, are moving Canada in the wrong direction. Thank you.